Can you have them state their name when they come to the podium?
Bochin.
Who?
Joe Biden. Yeah.
Sir, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does either side wish to be heard on bond?
Oh, I didn't.
Sir, before you say anything else, let me tell you why you're here today. You're entitled to be seen by a judge within 24 hours of your arrest, and that's why you're here today. It's for me to tell you about the charges, tell you whether I found probable cause based on the affidavit. And probable cause means there's cause to believe you probably did what they're accusing you of. I'm not saying you're guilty. I'm not saying the state is going to prosecute it to a jury trial. I don't know if they will. But for purposes of this hearing, there is probable cause. Now, you can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that? You have to answer out loud.
Yes.
All right. I've appointed an attorney to represent you. She's standing right next to you. If you have a question, do you want to direct it to her first and then maybe the court? I thought.
Thank you, Your Honor.
All right, I'm sorry. Did either side wish to be heard on bond?
Your Honor, state would just bring your attention that he does have at least 4 prior failures to appear and at least 2 open warrants out of Georgia currently. So state's just concerned regarding his willingness to show back up to court to deal with these charges, as it is a violent offense where a victim is involved. So state would just ask that you take that into account when setting his bond.
He's also currently out on bond on 2 different criminal charges.
I see that there's competency concerns. He was appointed an expert to be evaluated, Dr. Danziger. So we have that in both cases, Your Honor. There's competency issues.
When was Dr. Danziger appointed?
October 20th of this year, which is why he was released on
Joe
ROR.
Biden.
I do see that both are in comp proceedings, so state would request no action on his out on bonds.
All right, so here's what I'll do. Mr. Chen, your bond is $500 in this case. With special conditions, you can have no contact with the victim. You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand? You have to answer out loud.
Yes, ma'am.
And I'll take no action on your out on bond cases based on the representations from the attorneys. Good luck, sir.
So, mark through, Long's at 5, PC, PD appointed, no contact with victim.
My name is Adrian Rodriguez.
And then she took no action on his out on bond cases.
05335 Brevard County.
Mr. Rodriguez, you're here because you have several warrants out of Brevard County. The bond on those is $5,000. We'll notify them that you're here so they can transport you, but because you have a bond, if you're able to post it, you can get out. Good luck.
Excuse me?
Oh, wait, come back.
They said she's.
You have to bring him back. I didn't realize on. Thank you for catching that. I'm sorry, sir. I was wrong. You only have bond on the aggravated assault with a deadly weapon of $5,000, and then robbery is $5,000. The battery DV and the violation of condition of pretrial release, and that's it. You have no bond on those, so you cannot bond out, but we will notify them you're here so they can transport you. Good luck, sir. Wonder where that is. Spanish is next. Let's see if it works today, guys. Everybody hold your breath.
No, I don't need Spanish interpreter. I'm fine.
Oh, you don't?
The victim, Your Honor.
Oh, the witness does. That's right. Everybody hold your breath. It didn't work yesterday.
Your Honor, can you press the button to release the Oh, never mind, she got it.
Good morning, Your Honor. This is Ricardo Morales, Spanish interpreter. I have been previously sworn.
Good morning.
Good morning.
I don't need you to connect with the podium. I need you to be on the overhead speaker for a witness's benefit, please.
Certainly, Your Honor.
All right, please tell me your name, sir.
My name's Arif Ali.
I need you to wait because the interpreter is going to interpret everything we say right after we say it. So wait, tell me your name again.
Arif Ali.
Reef Ali.
Sir, you're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you.
Señor, usted se encuentra aquí por una acusación de agresión física de naturaleza doméstica. Determinamos que hay suficiente indicio de criminalidad y se designará a un defensor público para que le represente.
Good morning, ma'am. Do you wish to testify today?
Yes,
Buenos días, señora. ¿Usted quiere testificar el día de hoy?
sí.
Yes.
I need you to raise your right hand to be sworn.
Levante su mano derecha para prestar juramento.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Jura solemnemente decir la verdad, toda la verdad y nada más que la verdad. Lo jura ante Dios.
State your name for the
Yes.
record, please.
Por favor, indica su nombre para que conste en el acta.
Pamela Pinales Beltré.
Pamela Penales Beltré.
Let me see if the state has some questions for you.
Permítame ver si la fiscalía tiene algunas preguntas para usted.
Good morning, ma'am. Can you please state your name to Mr. Ali?
My apologies, counsel. Can you repeat the question once more?
Good morning, ma'am. Can you please state your relationship to Mr. Ali?
Buenos días, señora. ¿Puede indicar cuál es su relación para con el señor Ali?
Él es mi esposo.
He's my husband for 8 years.
Are you afraid of him?
¿Usted le teme a él?
For the record, she's nodding her head yes.
I think she said something, but the interpreter was talking at the same time. So if you could ask her to repeat her answer.
Por favor, ¿puede repetir su pregunta? Su respuesta, perdón.
Yes,
Yes.
Has anything like this ever happened before?
¿Algo como esto había sucedido anteriormente?
yes.
Approximately how long ago would you say the last time was?
¿Hace cuánto tiempo fue esto?
La última vez fue cuando ya yo decidí a la policía, porque él fue a la habitación y me agarró. El policía le había dicho que no podía acercarse a mí, que yo tenía que estar de un lado y él del otro. Y él fue a la habitación en la madrugada y me agarró por los brazos y me jamaqueó y se quedó mirándome y se fue. Ahí yo cerré la puerta con la cama, porque yo estaba durmiendo con los niños, y ya después me levanté y llamé a ayuda a la línea de crisis y ellos me dijeron que tenía que ir a la policía y por eso es que yo estoy aquí.
Well, the last thing that happened is that they decided to call the police because he had grabbed me. Police had told me that he could not enter into contact with me or grab me in any way, that I should be on one side and he should be on another side of the room. But then he came into my bedroom, grabbed me, and started shaking me. And after that happened, I closed the door and went to sleep with my children. Then the next day, I called to Protective Services, and that is why I am here today.
Do you believe drugs or alcohol were involved in this incident?
¿Usted piensa que el alcohol y la droga tuvieron que ver con este incidente?
Sí,
Yes.
Which of the two?
¿Cuál de las dos?
ambas.
Both. Both.
And do you want to have contact with Mr. Ali while this case is pending?
¿Y usted desea tener contacto con el señor Ali mientras este caso se encuentra en vigencia?
No.
No. No.
State has no further questions, Your Honor.
No tengo más preguntas, señoría.
All right, any questions from the defense?
¿Alguna pregunta por parte de la defensa?
No, Your Honor.
No, señoría.
All right, thank you, ma'am, for coming. You can stay right there if you wish, or you can go back into the waiting room.
Muchas gracias, señora. Puede permanecer aquí en la sala o puede ir al salón de espera.
Ok, gracias.
Thank you. Anyone
Okay,
wish to
thank
be
you
heard
very
on
much.
bond?
¿Alguien más desea ser escuchado en cuanto a la fianza?
Your Honor, I'm going to ask for a $500 bond in this case. I don't see any violent offenses on his record. The only thing I see is DUIs and one grand theft. So I just ask that you consider that instead of $500 bond with a one-time return with law enforcement. I believe that if they are not living together, that this would prevent any further altercations from occurring.
Eso, señoría, pedimos que se fije la fianza en $500. No vemos ningún tipo de acto violento en el expediente, solamente vemos unos cuantos casos de manejo bajo los efectos del alcohol y un caso de hurto de mayor cuantía. Así que pedimos que considere fijar la cantidad de fianza en $500 y el regreso en una sola ocasión acompañado por las fuerzas policiales.
What says the state?
State has no objection, Your Honor.
¿Qué dice la fiscalía? La fiscalía no tiene objeción, señoría.
All right, Mr. Ali, I will give you a $500 bond.
Bien, señora Lee, voy a fijar la fianza en $500.
With special conditions, you can have no contact with the victim.
Con las condiciones especiales que incluyen no tener ningún tipo de contacto con la víctima.
Do you understand what no contact means?
¿Usted sabe lo que significa no contacto?
You have to answer again.
Yes, I do.
Sí lo sé.
You can't possess a weapon of any kind, a firearm, or any ammunition.
Usted no puede tener ningún tipo de arma o arma de fuego ni municiones.
You can't possess or consume any alcoholic beverages or any controlled substance without a valid prescription.
Usted no puede consumir ningún tipo de bebida alcohólica ni puede tampoco consumir ningún tipo de sustancia controlada a menos que sea una receta médica.
You'll be subject to random drug and alcohol screens.
Usted quedará sujetado a pruebas aleatorias de alcohol.
You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings.
Usted deberá mantener una residencia separada a la de la víctima, pero se le permitirá el regreso en una sola ocasión, acompañado por las fuerzas policiales para recoger sus pertenencias.
And you must comply with any plan set in place by DCF.
Y usted deberá cumplir con cualquier plan recomendado por el Departamento de Familia.
All right, thank you. Oh, thank you, ma'am.
Bien, gracias. Gracias, señora.
Do we have any other Spanish? I believe that's all we have for the interpreter.
Thank you, Your Honor. Have a great day.
You as well. Go ahead. Sir, tell me your name.
Kanzader.
Good morning, Judge.
Good morning.
My name is Adam Pollock, and I represent Mr. Kanzader. Your Honor, the reason we're here today is there had been a petition for writ of habeas corpus filed. There was a hearing held by Judge in front of Judge Falcone. He ordered the court, or he ordered the jail to produce Mr. Kanzader for an initial appearance hearing. Mr. Kanzader has been here for over 30 days without seeing an initial appearance judge. There is apparently an allegation that there's an out-of-state warrant from Georgia. Georgia has taken no action at this point to retrieve Mr. Kanzader from this jail. Your Honor has the authority under Florida Statute 941.16 to set bail. If I may approach the bench and provide the court with the statute.
Yes, thank you.
To give the court a brief procedural history of this case, prior to Mr. Kanzader being arrested this most recent time, he's been arrested twice previously on a allegation of a warrant out of the state of Georgia. Both times he has not been extradited to Georgia, to my knowledge. He had waived extradition the first time in Seminole County a couple years back. Georgia, I don't believe, did anything with it then. He was then rearrested about a year or two later. After that, he did not waive his right to extradition. And so he sat in the Seminole County Jail for a period of time. Georgia did not come and get him, and the Seminole County Jail released him. That was all laid out in the petition for writ of habeas corpus. I can provide the court a copy of that petition.
Yes, please. And what is the charge out of Georgia?
My understanding, it's a failure to appear or a violation of probation. I'm not quite clear. I think the authorities here for the jail can probably fill you in better.
It's a violation of probation, fleeing and eluding police.
Do you have it?
The copy of the warrant?
Yes.
Yes.
I'd love to see that too.
Okay.
Thank you. Thank you. Oh, it's from 2020. Okay. Has Mr. Kanzader not been to court since October 13th?
He was brought on that date to ask if he wanted to sign. He refused, back on the, sorry. Back on the 21st, he refused to sign, and then we brought him back 2 weeks later to present him with a pre-signed waiver. He said that he refused the pre-signed waiver, and that's when we brought back the paper the next week to sign him and hold him in for an additional 60 days.
Judge, the answer is he's not seen an initial appearance, Judge. I've been here representing Mr. Kennedy from the very beginning of his arrest. I showed up here in this courtroom requesting that my client be seen. I was advised by the jail staff that he would be seen later that week.
When was that?
The day he was arrested on the day after he was arrested initially, so I believe it was October 13th. So every day that week, I checked the initial appearance list to see if he had been present. On the list, he was not present, which necessitated us filing a petition for writ of habeas corpus.
Why wasn't he brought to court?
I was told it was due to a procedure that's been in place in Orange County. Judge Falcone did not think that that procedure was proper, and that's why he ordered him.
What's the procedure?
Apparently, there's a court order that says that out-of-state warrants do not see a judge.
I need to see that. What I need to determine is he entitled to this hearing, and is he entitled to a bond?
He-
I don't see any statute. I need the statutory authority for what you guys are asking me to do for an out-of-state warrant.
So
Because I
Judge,
don't have jurisdiction over Georgia.
right, Judge, you do have the authority. I provide the statute to the court, which gives the court the discretion to grant a bail.
It gives me discretion.
Yes,
I
ma'am.
may.
Yes, ma'am. And what I'm asking the court to do is to exercise that discretion in light of the fact it's been over 30 days that he's been sitting here in the Orange County Jail. He's not charged with a crime that is, that would not entitle him to a bond. He's not unknown to the state of Georgia. They've had opportunities multiple times to come and get him. I am representing him. This court can set a bail, and if a governor's warrant is eventually issued, he can then turn himself in on the governor's warrant to deal with whatever issues that need to be issued.
Your Honor, if I may.
Yes, please.
That is not my understanding or my reading of the statute that was provided by counsel. It says arrested upon the warrant of a governor of this state, which will be Florida. This warrant is not from a governor of this state. Instead, we're pointing to Burkhart versus Jean, which is a 4th DCA case. This is a Georgia issue, not necessarily a Florida issue. However, it's my understanding, and within that case law, it states that a court may not use a bond to short-circuit the extradition procedure, which would be granting the defendant a bond, short-circuiting extradition back to Georgia, given that the defendant will not sign a release to go back to Georgia himself. The state's only concern is if this court does grant him a bond, given that that Georgia case is a failure to appear, state's concern is he again will not appear. May I approach with the case law I'm referring to?
Yes, please. Thank you. I see. I'll try not to write on it. All right, thank you both. I appreciate the arguments, case law, and statute. At this time, I'm denying the request, Counselor. Do you need this back?
Yes.
Oh, Ms. Fleming, I almost said may. Here's your case. Thank you. Did you provide an order, Counselor? No, I don't. I need you to provide an order, Counsel, so it can go in the file. Thank you. Right.
Your Honor, as far as providing the order, how do you want me to submit that order? I can give you my email. Okay.
Perfect. Thank you. Tell me your name.
Jack Collins.
All right, Mr. Collins, you're here in 2 cases. The allegations are that you violated your probation. Did the state?
Yes,
Okay,
Judge.
great. If you could tell me, I wasn't able to advise him yesterday how he violated his probation.
Yes.
That's why we brought him back.
So the ASA yesterday did reach out to the officer, and it was determined that the 22 VOP should be dismissed. He does not have sufficient probable cause for a VOP on the 22 CF 7023 case. So state is requesting ROR on that case, on that VOP. However, in regards to the 2019, may I approach?
Yes.
I have multiple copies. So from what I was able to ascertain.
Thank you. Who's this? Is that him? That's not him. Does that look like him? Well, maybe I just can't tell. All right. Thank you.
Warrant from Volusia. And here is the order of probation for that case. So it's my understanding, after speaking to the officer, he was on probation in the 19 CF 5129 case, and that order of probation was for 4 years, which is on the order of probation that I provided the court and to defense. And he violated that by picking up a grand theft, more than 10,000, under 20,000, which is in that warrant for arrest from Volusia. So I believe that is the basis for his VOP,
I see.
but the 2022 VOP should be ROR'd.
All right, at this time, I'll release you on your own recognizance as to 2022 CF 7023, but you'll have no bond on the other case. And this is an Orange County VOP?
The new law?
No. The probation. Is he on probation out of Volusia or here?
Volusia.
Okay. I'm sorry? It's out of Orange? All right. I'm going to appoint an attorney to represent you. So stay in touch with your attorney, sir. Good luck. And Ms. Kennedy Swanson, I assume that you'll make sure that everyone who's here today knows that none of this is how any of this is supposed to go.
No,
Just FYI.
it's all unusual.
Jessica Kavanaugh.
Ma'am, you're here charged with battery on a person 65 years of age or older and battery domestic violence. I'm going to appoint the public defender's office. Ms. George, did you wish to be heard?
Yes, Your Honor, I was going to argue no PC. Based on the four corners of this arrest affidavit, it appears to just be a blanket statement by the officer. There are no facts or details outlined in the affidavit, so I just argue no PC.
Your Honor, state has no objection. State would ask for a 24-hour reset. It does appear that the officer just wrote a PC statement and not an actual narrative. So state would ask for 24 hours. The state has no objection to you setting a bond in case Ms. Kavanaugh wants a bond before it's reheard tomorrow.
All right, here's what I'll do. I'll set the bond at $5,000 on count one, $100 on count two. With special conditions, you can have no contact with the victim, maintain a separate residence, one-time return with law enforcement, and you can't possess any weapons. However, I'll give the state 24 hours. If they're not able to come up with probable cause and you are still here tomorrow, you might be released on your own recognizance. I just want you to know that. Good luck.
Your Honor, Cooksey refused.
I'll find his refusal a willing waiver of his appearance today. There is probable cause. Ms. George, I'll appoint your office.
Yes,
Did you wish to be heard on bond?
Your Honor, go ahead.
I would just ask for a reasonable bond, Your Honor.
The state has no objection. Would just bring your attention that he does have at least 3 prior BAT DVs and 6 prior failures to appear.
Yes, I saw that. Thank you. His bond will be $15,000 on count 2, $1,000 on count 1 with special conditions, no contact with the victim, no weapons, firearms, or ammunition. Maintain a separate residence, guys. They,
They did reside as a family.
in the woods.
I don't know how to.
I don't know how to order that he has to not go back to the campsite.
The state would just say a tent is a residence, or is at least what they're using as a residence.
It's, this is a tough one.
Did you provide a one-time return, Your Honor?
State has no objection.
Okay, I'll say maintain separate and one-time return.
Thank you.
It's gonna work.
Andrew Dolphus.
Sir, you're here because a Capias was issued for your arrest for failing to appear for arraignment on charges of criminal mischief, tampering with a witness, battery domestic violence, and resisting without violence. There's no bond authorized. I'll appoint an attorney to represent you. Good luck, sir.
DeJuan Jefferson.
Sir, you're here charged with written threats to kill and assault domestic violence. There is probable cause. I'll appoint an attorney to represent you. Sir, while you're in the courtroom, I need you to look at me or this wall, but don't look at the witness. Do you understand? You have to answer out loud.
Yes.
Good morning. Did you wish to testify?
Yes.
Please raise your right hand.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Desiree Brooker.
All right, let me see if the state has some questions.
Good morning, Ms. Brooker. Can you please state your relationship to Mr. Jefferson?
Father of the child.
Are you afraid of him?
Yes.
Has anything like this ever happened before?
Yes. This is the first time he ever been caught. I have called multiple times. It's only the first time they actually got him.
Okay. Do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with him while this case is pending?
No, but he keep finding me.
And if anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes, I don't want it to occur. I want him to stay. I'm not comfortable. I have to hide. I've been hiding for 4 months. I can't go nowhere. He is. I have a child.
Your Honor, state has no further questions. However, the court's not able to hold him no bond at this time, given that the nature of both of the charges.
Right, so ma'am, I'm terribly sorry that you're in this situation. And what I can tell you is, unfortunately, Florida law does not allow me to hold him at no bond. There are very few offenses in the state of Florida for which you are not entitled to bond. And unfortunately, in this case, the law requires that I grant him a bond. So I'll hear everything you say and everything the defense says before making a determination about amount and conditions, but I am sorry, I am required to give him a bond.
And what about his probation? He's on probation.
Where?
In juvie, Your Honor.
Oh, in juvenile? Let me see if the state can figure that out.
Your Honor, upon picking the juvenile probation before, juvenile probation has to file a warrant.
All right. So they might file a warrant for his arrest for that probation violation, but at this time, there's not one. I'm really sorry.
Your Honor.
Okay, well, you need to let him know to stay away from me. He need to leave me alone. Like, just stop. It's no talking. It's no communicating. He just won't violence. I can't talk to him. I can't. It's nothing. He just won't stop.
I will order that he's not allowed to have any contact with you via telephone, social media, friends and family, anything. And then if he does, you can call the police, and that's a violation of the court's order, as well as a new crime.
Okay.
Your Honor.
Let me see if the defense has any questions for the witness.
No questions, Your Honor.
All right, thank you.
May we approach?
Yes. All right, does either side wish to be heard on bond?
Your Honor, I would just ask for a reasonable bond. He has some prior history from juvie, but he has no failures to appear, which is indication he will appear for court. He has a community ties. He's lived here for well over a year, so I just ask that you consider that when setting the bond.
And state will just leave it within your discretion, Your Honor, taking into account everything that's been said in court this morning.
Was he placed on probation in August of this year?
1 second.
That's the note that I have from pretrial release. And was it for possession of a firearm?
Exactly.
Yes. Yes.
All right, Mr. Jefferson, I need you to listen to me carefully. As you heard me just say, I'm required to give you a bond, so I will. But I want to be sure that you hear the conditions that I'm placing on your bond. Because if you violate those, you'll be arrested again. Do you understand that? You have to answer out loud.
Yeah.
On count 1, your bond is $20,000. On count 2, it's $1,000. With special conditions, you can have no contact with the victim. No contact means you cannot speak to her. You cannot see her. You cannot send a message on the phone. You cannot send a message through social media. You cannot send a message through friends or family. Do you understand?
Gotta say yes.
Yeah.
You can't be within 1,000 feet of her residence or place of employment. You can't have any contact with any minor child under the age of 18. You can't possess a weapon of any kind, firearm or ammunition. You can't possess or consume any controlled substance without a valid prescription. You'll be subject to random drug screens while you're out on release. Do you understand?
Yeah.
Any other conditions the state would request?
No, Your Honor.
Your Honor, only as to marijuana, could there be a 30-day grace period for the drug testing?
Yes. Good luck. Thank you, ma'am. Good luck.
Tony Key.
Mr. Key, you're here charged with aggravated battery, domestic violence, causing great bodily harm. I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard in this case?
In this particular case, Your Honor, I was
You got the wrong person. My brother's the one that was arguing at my mother. It wasn't.
I'm guessing you just said this to him, but let me just say, Mr. Key, I understand that you want to tell me some things, but I want to make sure you understand that everything you say is being recorded and can be used against you later. I've appointed an attorney to represent you, so you might want to talk to her first and then listen to her advice about whether to say it to me. The only thing we're here to do today is determine if there's probable cause for you to be held in jail. That's it.
Yes, ma'am.
And I read the affidavit, and I have some questions about that.
Yes, Your Honor. I read the prior cases, Your Honor. I would just ask that you set a bond on, because this is an add-on charge, I would ask that you set a bond, and if he does not bond out, allow the state the 24 hours to provide the supplement. Because based on this affidavit, it just says, see initial report.
Right. And I don't have the initial report.
Yes, Your Honor.
Agreed, Your Honor. State doesn't believe there's PC within this affidavit. It doesn't state, it states what injuries the victim sustained, not what happened for her to sustain said injuries. So
Right.
state would ask for 24 hours.
All right, I'm going to give the state 24 hours to see if they can get additional information for the court to make a determination about probable cause. However, in the meantime, Mr. Key, I am going to set a bond for you. Your bond is $5,000. You can have no contact with the victim. You can't possess a weapon of any kind. Were you living with your mother?
I do believe they have the same address.
Yes, Your Honor.
Okay, I'm going to order you to maintain a separate residence and give you a one-time return with law enforcement. If you don't post that bond, you'll be back tomorrow. If the state's not able to come up with more probable cause, you might be released on your own recognizance, okay?
Yes, ma'am. Yes.
Good luck, Mr. Key. You have 2 warrants. One warrant charging you with stalking, domestic violence, and trespass in an occupied structure. And the other warrant charging you with burglary of an occupied dwelling with assault or battery. Another judge has already found probable cause in both of these cases. I'll appoint an attorney to represent you. In the 22 CF 10361, you'll have no bond. However, even while in custody, you can have no contact with the victim. Do you understand?
No.
Mr. Laro,
She's talking to you. You gotta listen to the judge.
did you hear what I said?
I don't-
Even while in custody, you can have no contact with the victim. Do you understand? In 22 MM 71270, your bond will be $15,000 on count 1, $1,000 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. You can't return to the victim's residence for any reason or be within 1,000 feet of her residence or place of employment. Did anyone check the date on the out on bond case?
Yes. Looks like he was seen at IA's on August 25th, Your Honor.
At this time, I'm revoking your bond in 22 MM 5040.
No.
Nicholas Lindsay.
You're here in 22 CF 13112. A warrant was issued for your arrest, charging you with aggravated battery with a weapon, dating violence, and battery, dating violence. Another judge has already found probable cause. I'll appoint an attorney to represent you. Ma'am, do you wish to testify?
I'm just here to drop the charges. I don't want to.
Hold on. If you want to speak to me, you have to be sworn in. Raise your right hand. Sir, while you're in the courtroom, look at me or that wall. Do not look at the witness.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record.
La Jessica Wilson.
All right, let me see if the state has some questions for you.
Good morning, Miss Wilson. Can you please state your relationship to Mr. Lindsay?
My boyfriend.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred where you did feel threatened, would you feel comfortable calling
Say,
911?
can you repeat that again?
If anything ever happened in the future where you did feel threatened, would you feel comfortable calling 911?
Yes.
And do you want to have contact with Mr. Lindsay while this case is pending?
Yes.
All right, state has no further questions, Your Honor. However, given Ms. Wilson's earlier statement about possibly wanting to drop later on, I am giving her a card with the case number.
All right, any questions from the defense?
No, Your Honor, no questions.
All right, does either side wish to be heard on bond?
Your Honor, I just ask that you allow non-hostile contact. I don't see any other violent history. No failures to appear. All there is it looks like trespass and a drug charge under 20 grams of cannabis. So I just ask that you consider that when setting the bond and also allowing non-hostile contact. And if anything occurs in the future, he could be brought back here and held at no bond if he violates the court's order.
State has nothing further to add on to defense's argument.
All right. Thank you. Thank you, ma'am. You can stay right there or you can go out in the room, whichever you wish. All right, Mr. Lindsay, your bond will be $5,000 on count 1, $500 on count 2. With special conditions, you can have no contact with the victim at this time. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Were you living together?
No, ma'am.
Okay. So at this time, you can't return to her residence. You understand that?
Yes, ma'am.
Any other conditions the state would request?
No, Your Honor.
All right, good luck.
That's it.
Marquise Devon, Todd Lowry.
You're here in 22 CF 13602, charged with aggravated assault with a firearm, domestic violence, and battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Good morning, ma'am. Did you wish to testify? No? Okay. Does either side wish to be heard on bond?
Your Honor, state would just ask for a reasonable bond, given we don't have any input from the victim or witness.
Ms. George? All right, sir. At this time, your bond on count 1 is $20,000. Count 2 is $100. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. But you can't coordinate that with the victim. Do you understand? Good luck. Good luck, ma'am.
Bree White.
22 CF 13625. Ma'am, you're here charged with battery on a person 65 years of age or older. There is probable cause, and I'll appoint an attorney to represent you. Just a moment. I'm going to give them a moment. All right. Good morning, sir. Did you want to testify today?
Yes,
Thank you. Raise your right hand.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
John Meyer.
Let me see if the state has some questions for you.
Good morning, Mr. Meyer. Can you please state your relationship to Miss Wick?
Yes. Listen to me.
What is your relationship to Miss Wick?
She's my stepdaughter.
Did you say sister?
My stepdaughter.
Stepdaughter. Are you afraid of her?
No, I'm not.
Can you step a little bit back behind the microphone? Thank you.
I'm sorry, ma'am.
It's okay. We want to be able to hear you.
Okay, ma'am.
And do you want to have contact with Miss Wick while this case is pending?
What's that, ma'am?
Do you want to have contact with her while this case is pending?
Yes, I do.
Do you believe drugs or alcohol were involved in this incident?
No.
And if anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes.
State has no further questions.
Any questions from the defense?
No, Your Honor.
All right, thank you, sir.
And
She does qualify for PTR. State has no objection.
I see that.
now I was going to ask for pretrial release, Your Honor.
All right. Ma'am, I'm going to place you on pretrial release. Let me ask, Ms. Fleming, he did say he wanted contact, right?
Yes, Your Honor.
All right, at this time, I'll order that you can have only peaceful contact with the victim. Do you understand what peaceful contact means?
Yes, Your Honor.
Don't even raise your voice. No yelling, no screaming, no pushing, no hitting.
No,
Don't even raise your voice.
I won't, Your Honor.
You can't possess a weapon of any kind, firearm, or ammunition.
No.
All right, good luck, ma'am.
Catherine Bandy.
You're here in 22 MM 7887, charged with battery domestic violence. There is probable cause. I see that she doesn't qualify, Ms. George.
She does?
She does not. For your office,
Oh.
for appointment of your
I was like,
office.
oh, I thought-
So sorry.
Okay.
Ms. Bandy, you're entitled to be represented by an attorney. You have a right to be, but you make too much money to be represented by the Office of the Public Defender. So if you want to be represented by an attorney, you're going to have to hire one. You understand?
Yes, ma'am.
Okay.
As a friend of the court, Your Honor, she did have a question. Could I answer that for her?
Yes, please.
And she does qualify for PTR, and state has no objection, and I believe she'd be going back to Texas.
I saw that. Thank you.
As a friend of the court, Your Honor, yes, she does qualify for pretrial release. She would like pretrial release. Additionally, I would ask that you allow her to return back home to San Antonio because she's in active duty military. As long as she maintains all of her court appearances, Your Honor.
All right, ma'am, I will place you on pretrial release. With special conditions at this time, you can have no contact with the victim. Do you understand that?
Yes, ma'am.
You can't possess a weapon unless that's part of your job. You can for purposes of your job only.
Yes, ma'am.
You can return to Texas. Any other conditions the state would request? I didn't see alcohol. All right.
No, Your Honor.
Good luck, ma'am.
Dawn Danforth.
22 MM 7885. Ma'am, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does either side wish to be heard on bond?
Your Honor, she does qualify for pretrial release. I would ask for pretrial release in this case. I don't see any convictions on her record. Additionally, I would ask for a one-time return with law enforcement to gather any belongings she may have.
Your Honor, state has no objection to PTR. I do believe a child witnessed it, however, I don't believe DCF was called. We'll just bring that to your attention.
All right, thank you. All right, Ms. Danforth, I'm going to place you on pretrial release with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. But you can't coordinate that with the victim. You understand?
So just, can I ask a question?
Your Honor, could we do a maintain separate residence with the one-time return with law enforcement? I believe you did
I did
order that because the victim moved back to Texas, Memphis. She doesn't live there.
That's fine. I'm ordering you that you can't live with the victim because I don't have jurisdiction to order the victim to move. I only have jurisdiction over you. So if the victim's not living there, you can live there. But if the victim's living there, you cannot.
Okay.
Good luck.
Good morning, Percy Hardy.
Good morning. How about case number? Yeah, but there's no case number on here. That's one thing. Sir, you're here in 22 MM 7888, charged with violation of a domestic violence injunction. There is probable cause. I'll appoint an attorney to represent you. Does either side wish to be heard on bond?
Your Honor, state would only bring your attention to, I believe while the injunction is still in place and is still active, the victim did allegedly give him permission to be outside of her property, therefore indicating that she is not fearful of Mr. Hardy. The injunction is still in place, so there is PC, however, state would just ask that you take that into account.
I would as well, Your Honor. Additionally, on the out on bond, I'd ask that you take no action, given they're not related, and he was arrested August 11th, and to date, no information has been filed.
Has no information been filed yet?
That is correct, Your Honor.
Here's my concern, Mr. Hardy. Part of being out on bond is a willingness to comply with court orders. The fact that you're here with this charge and out on bond and have been arrested for another law violation indicates to this court that you have an unwillingness or an inability to comply with court orders. That concerns me. I'll give you a moment.
Your Honor,
Before you say anything else, can I see the attorneys really quickly? Okay. God bless you. All right. Mr. Hardy, here's what I'm going to do. Based on the arguments of your attorney and what I read in this case, I'm going to set your bond at $1,000, but you can't have any contact with the victim right now. You understand that? You have to answer out loud.
I don't have no, I'm disabled, y'all. I don't have no money.
Your attorney can file a motion to reduce that.
My grandson attacked me with a bat, and she went down there and did this to keep me, keep him in the house with her. It ain't about me and her, Your Honor. Me and her don't have no domestic violence.
So unfortunately, you are correct. It is not about you and her. A judge has ordered you not to go to her house. You can't go there. It doesn't matter if she calls you and asks you to come, you can't. So that's what the charge is. You're violating a court's order. That's the problem. But because that order is in place and there is probable cause that you violated it, I'm stuck too. There is probable cause, so there's nothing I can do about that today. Now, your attorney can talk to the state, negotiate on your behalf, see if they can get the state to drop the criminal charges, and the state might, I don't know. But as of today, they're not.
You do not qualify.
You don't qualify for pretrial release, so I can't put you on pretrial release. You could ask me for a $500 bond.
Yes, Your Honor. I would ask.
Right, I'll set his bond at $500, no contact with the victim, no weapons. You can't return to her house. And again, based on the arguments of your attorney, I will not revoke your bond. Good luck, sir.
Oh, Your Honor, could he have that one-time return because his vehicle is
Oh,
at the
yes.
residence
Yes, one-time return.
with law enforcement? You gotta call law enforcement.
David Jones?
You're here charged with battery, domestic violence. There is probable cause. There is probable cause. I'll appoint an attorney to represent you. Ms. George, I have to tell you, I find the facts in this case disturbing, as well as his history. So if you want to make an argument, I'm all ears, but I got to tell you, I'm concerned. He's got several prior failures to appear for court.
I would just ask for a reasonable bond, Your Honor. I understand all the concerns.
All right, sir, your bond is $1,000. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am, I understand, Your Honor.
You cannot speak to her, you cannot text her, you cannot Snapchat her, you cannot send a message through friends or family, any kind of social media. You understand that? You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Did I say no weapons? You can't possess a weapon of any kind, firearm, or ammunition. Good luck, sir.
David Walker.
A warrant was issued for your arrest, charging you with battery, domestic violence. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $500. With special conditions, you can have no contact with the victim. You cannot return to the victim's residence. You can't possess a weapon of any kind, firearm, or ammunition.
Your Honor, DCF was also contacted.
You must comply with any plan set in place by DCF. Good luck. Sir, you're here for a warrant out of Brevard County. There's no bond on that warrant. We'll notify them you're here so they can transport you. Good luck.
Good morning, Your Honor. Alejandro Marriaga.
You're here for a warrant out of Polk County. It looks like the judge ordered that you be released on your own recognizance with a valid address.
Yes, ma'am.
So if you can provide corrections with a valid address, you'll be released.
It's on the report, ma'am. Would you like me to state it on the record, or?
Yes.
My address is 1591 Cheshire, Cheshire, Oaks Lane, Orlando, Florida, 32825.
Wonderful. Thank you. Good luck. Yes. We're going to have you fill it out. I thought they would do that. Corrections would do it when they release him, but. Yep. Well, that's why I said go ahead and say it on the record, because then it's in the minutes. And I just wanted something, but that was smart. Good job.
Hello, Amber Dozier.
Case number 2022-CF1862AO.
You're here for violating your community control. The allegations are that you moved without first procuring the consent of your probation officer.
I can't
And
hear you, ma'am. I couldn't understand what you said.
You're here for violating your community control.
I didn't.
Well, that's what the warrant says.
Okay, yes, ma'am.
And so the allegations are that you moved, you changed your residence, and that you failed to complete your community service hours. So you're going to have to address that with the judge
Yes, ma'am.
who signed the warrant.
I changed my address and I didn't complete my community service hours.
Right. I'm sorry. Judge Strobridge signed the warrant. I'll appoint an attorney to represent you. You have no bond at this time, so I would call your attorney right away.
Okay, would I get a leg monitor?
No, you have no bond.
No bond? I got to see her first? Yes.
Right.
Okay, thank you. You have a good day.
You too.
Christopher Garcia Burgos.
You're here on 2 violations of probation, and the allegations are that you committed new law violations, burglary with a battery, criminal mischief. At this time, you'll have no bond on those, and I'll appoint an attorney to represent you. Good luck, sir.
This 2008 case, 2007 case.
Walter Pixon.
Sir, you're here in 2, go ahead.
Case number 2014-CF149368.
And is he not here on the 16? I have both.
I have both.
Case number 2016-CF3068.
The allegations are that you violated your probation by committing the new law violations of resisting an officer with violence and battery domestic violence. So at this time, you have no bond, and I will appoint an attorney to represent you. Good luck.
Giovanni Gonzalez. Giovanni Gonzalez.
Case number 2022-CT883AO.
So you're here for violating your DUI probation by committing the new law offense of driving while license suspended. At this time, there's no bond authorized, and I'll appoint an attorney to represent you. Counsel, it's a misdemeanor.
I will enter denial, Your Honor.
Date. They need a date for his VOP. They need a date for his VOP.
Division 83, VOP status, December 12th at 1:30, courtroom 6C.
Good luck, sir.
William Bose.
Good morning, Your Honor. Joseph on behalf of Mr. Bose.
Good morning. Go ahead.
Your Honor, we're here on a motion to set bond on an extradition warrant out of the state of New York. Mr. Bose has a at-large warrant from the state of New York for a larceny charge, that it would be similar to a third-degree felony that we have here in the state of Florida. This is not a warrant whereby Mr. Bose has avoided service or has fled the state of New York to avoid arrest. Mr. Bose is a local resident, and his wife is here to testify on his behalf. We are asking this court to consider setting a bond in this case under 941.16. I know the court did have that statute previously today. I have another copy of that for you if necessary. I know the state earlier made an argument in regards to that statute and what it allowed the court to do and what it didn't allow the court to do. If I may make argument, I'll let the state speak first, so.
Well, it's your motion, Counselor, so.
Okay, that's fine, Your Honor. The state earlier made an argument to this court that something to the extent, and I don't want to misquote her, so I apologize if I do, that the warrant would need to be issued by the governor of this state, which is the state of Florida. I would argue that that is a condition that is a court can set. In theory, the court can set a bond on an extradition warrant, allow Mr. Bose to bond out and require him to turn himself in the jurisdiction that he has a warrant in within a certain period of time. And what we are requesting this court to do, and what we're going to request this court to do, is to set a bond in this matter, allow Mr. Bose to turn himself into New York personally within a period of time as designated by the court, whether that's 24 hours, 72 hours, a week, whatever it is that the court deems is necessary to satisfy a condition of this bond. In turn, Mr. Bose would reappear before the court in a future court date and show the court that he has in fact turned himself in. He has already waived extradition to be transported up to the state of New York. Unfortunately, there is some uncertainty as to how long that can take when it does come to extradition. One of the appearance before this judge is one of the conditions that you can set, though. So we are asking this court under statute 941.16 to set a bond in the amount of $5,000 from Mr. Bose, set a court date for early next week to allow Mr. Bose to reappear after turning himself into New York for a offense that is bondable on. This is not a life felony or another type of charge that this court could not grant a bond pending extradition for. So,
Why isn't there a bond?
what he would need to go up to New York. New York doesn't have surety bonds; they have appearance bonds. So, in theory, he would be able to turn himself into New York, probably be out within a few hours without having to place a bond up there. I don't think they set bonds in New York on cases, at least in my experience, and I have practiced in New York pro hoc. In theory, he would just need to turn himself in. The warrant was an at-large warrant. We do believe we know why it was issued. It was issued by the New York Police Department for a grand theft involving Mr. Bose's business. At least that's what we believe at this point, based on other civil filings that have been related to these matters, and that the warrant would only be an appearance warrant. Mr. Bose doesn't have a no bond status up there as far as we are inclined, although New York Police Department was not inclined to provide us with more details of the warrant, as they don't have to at this point.
When was the warrant issued?
I would defer to Orange County on that because they have more exact information.
Also, Judge, I do have a letter here from the DA's office in New York saying that they have already made pickup arrangements on him.
All right, thank you. I couldn't find the date. It's this little tiny thing right in the middle. Like, why is it in the middle of the page? When was he picked up here?
He was picked up last week, Your Honor. He did not know the warrant existed. It was the 14th, Thursday. He did not know the warrant existed until law enforcement appeared at his residence that morning, and he went into custody.
Right,
without
what
it.
says the state?
Your Honor, state's just gonna leave it within your discretion, given.
I have testimony from his wife too, Your Honor, if you're inclined, if you'd like to hear from ties to the community and what her plan is. Likewise, I can also proffer to the court that she has come to the courthouse today with his passport. However, they would not let her in with it. If the court wants us to surrender the passport, we will.
Do you have the indictment?
Um,
Do you have any other information or just this?
yeah, I
warrant?
can.
Okay, thank you. It says grand larceny in the first degree. And it says, counsel, they've already made arrangements to pick him up. They're coming to get your client.
Your Honor, understanding that my experience in having dealt with these extradition matters is arrangements can take still several weeks, despite the fact that they have made these arrangements. I'm not sure who the arrangements have been made through, whether it's the U.S. Marshal's Office or if they have personally themselves sent some sort of transport down there. However, in my experience, trips to New York usually take an extended period of time because of the nature and circumstances of New York City and the boroughs. I don't know what borough this might be out of, and I apologize, they wouldn't give me more details of that.
It says they're coming to get him on November 29th.
Understood, Your Honor. If it's inclined to do that, we'd still ask this court to set a bond and allow him to turn himself in, because it will take several days for him to get up to New York to turn himself in. Testimony that as I've outlined in my motion, Mr. Bose does run his own business, Direct Airways, which does charter private airplanes for people. He is the sole employee and does run this business. Right now, with him being incarcerated, even for a few more days, it does cause a great detriment to him and his family in their ability to make pay bills and or generate revenue. Again, if the court says we need Mr. Bose up in New York tomorrow on Thanksgiving, I think the family is inclined at this point to get him up there to execute the warrant. Should the warrant be executed in New York before the 29th, they'll cancel the transportation plans, in my experience, and move forward from there.
But even if he goes tomorrow of his own volition, he can't be flying planes for other people. So it's not going to get him back to his business. He'd be in New York.
Yes, Your Honor. He's more of a coordinator, travel agent, for lack of a better term. They coordinate these private jets for individuals around the country to be transported from various areas. Not just small trips, but from like New York to Colorado. During this time of year, obviously, it's a very important and profitable time of year for Mr. Bose. So in theory, he would not be the one flying the jets. He would be staying here in Orlando, Florida, upon release in New York. Again, I do believe if he did turn himself into New York, in my experience, he would probably be released within a few hours after booking with an appearance, a surety on that, and given a future court date. The New York courts, while voluminous, are somewhat efficient. So.
I'm not inclined to do this, and I don't agree that this is an emergency motion to set bond. I don't see anything that entitles your client to bond.
Your Honor, the only other argument I can make here at this point is that if this, while the 29th is the date listed as pickup, in our experience, that date isn't always certain or assured. As I said before, I don't know who they've contracted with to pick up the client. A lot of times it's the U.S. Marshal's Office, which could lead to a several day and or week trip by bus up to New York City. Unfortunately, not by direct airway flight or a direct bus trip. I recently had a client who was extradited up to New York, and it took over 30 days for him to leave Seminole County Jail and get to New York City. So, and I can give the court the case number on that case if inclined.
All right, here's what I'm willing to do. I'm not inclined to grant this. I'm still not hearing anything that is that compelling to me. However, you can stay and I will consider this while getting ready for the second session. If you want to do that.
I will, Your Honor. When is the court?
I'm going to talk to them right now.
Oh, okay.
That's what I'm going to do, is talk to everybody and see what they want to do.
Okay.
How much time they need, and then I'll determine when we're starting and that kind of thing.
Thank you, Your Honor.
All right. Sorry. I'm not making a determination right now.
I understand.
So I don't know if you guys need to stay or not. One second.
Are you done with those papers?
Yes. All right, I'm going to be in recess.
I don't know if you have the PDs or the add-on. Do you have Grant or Harris?
Both. Go.
Okay.
Whatever you want.
22 CF 11543, Michael Harris. Granted, notice of non-filing. Nicole Johnson, 22 CF 11159, granted, notice of non-filing. Charles Conyers, 22 CF 12338, granted, notice of non-filing. Terrell Golding, 22 CF 12465, granted, notice of non-filing. Kiera London, 22 CF 12349, granted, notice of non-filing. Willie Joseph Carr, 22 CF 12036, denied, and information was filed. Christopher Connor, 22 CF 12302, denied, and information was filed. Matthew Krasinski, 22 CF 12277, granted, notice of non-filing. And Dolores Grant, 22 CF 12301, granted, notice of non-filing.
Oh my gosh. And she even did it like, bam. All right, well, fair enough. That's way better. All right, we're in recess.
The other, it's never comfortable.
I denied it.
I always said I was gonna move away from
Sorry.
Florida. I should have.
All right, go ahead and call your case, Counselor.
Yes, Your Honor. Joseph Flynn on behalf of William Bowes.
And Ms. George, if you needed more time, I don't need you in here right now. We're going to do this case.
Oh, yes, Your Honor.
Okay. All right, so I took the recess and tried to do any research. I tried to do additional research, and I couldn't find any other information. So unfortunately, Mr. Bowes, at this time, I don't feel comfortable granting your attorney's motion without additional information. I'm required to make decisions based on the information that I have in front of me. And in Florida, you haven't seen this, but your attorney has seen this all day. When I have warrants, I have the affidavit for the warrant. I have the warrant signed by the judge. I have lots more information. In this case, I don't have any of that. And I was unable to get any more information. So at this time, Counselor, I'm denying your motion.
Would the court be willing to deny it without prejudice at this point in case we are able to come into additional information? We have contacted the DA's office up in New York and the New York Police Department. Unfortunately, all we've been able to obtain is the charge. That's it. So,
Yes, but I'll also tell you, I'm not assigned to the jail.
yes.
So if you want to prepare an order that says that, I'll
Yes.
deny it without prejudice, but also make sure that you change, it says done and ordered in chambers. It needs to say open court.
Yes, Your Honor, let me write that down.
And then if you're able to get additional information, it won't preclude you from filing another motion.
Thank you, Your Honor.
I'm sorry.
Thank you.
Good luck, sir. Good luck, ma'am. Okay, so I'm not signing, I did sign this order, but we're shredding it because he's going to provide a new one. Do you need this? That's the motion and all that? All right. Now is everyone else ready?
Thank you.
Yes, Judge.
Ms. George?
Oh, yes, Your Honor. I'm sorry, I didn't.
I don't think we realized that was directed at us.
Sorry, everyone else, that's all of you. For the first half of the docket, it's all like the misdemeanor stuff. Can you just, when they come in, just tell me, you say their name,
Yes, Your Honor.
just say everything and we'll run with it. Ready? Oh. I think, can you shred that too?
This for Michael Hosteller.
Let me see this one. And Your Honor, in 2022 MM 7789AO, there was an offer to resolve. However, Mr. Holsteller has an open competency case in 2021 MM 6476AO, which is the out on bond case. He has been deemed incompetent to proceed by the judge in that case. And given that, I would ask that you stay the bond set on the trespass and take no action on the out on bond.
All right, sir, I will do that. This was a warrant, so probable cause has already been found. I'll appoint your office, Ms. George. I'll stay the bond with a no return and take no action on the out on bond case. Sir, stay in touch with your attorney, okay?
Yeah.
Good luck.
Let's see arrow.
Interesting. Did she just get brought up? I was looking for her. No. She wasn't with the female. By herself? Your Honor, can we call Ms. Mack back? Because I wasn't able to speak with her.
Is that who that is?
Mm-hmm. Yes, Your
Yes,
Honor.
that's fine.
I'm gonna speak to her in a second.
That's not who this is. Do you have him in order? I don't have him in order.
Because on this case, I'm not gonna do anything. Okay?
Yeah, do you mind? Because, well, who's this?
So you're,
Wait, Sean Gibbons.
hmm?
What's he charged with?
Not sure. I'm sorry.
Okay, I found it. Can you hold the rest of them in order? Here's mine. 22 CF 13405. Mr. Gibbons, you're here charged with lewd or lascivious conduct and lewd or lascivious exhibition by warrant. It's been signed by another judge. Probable cause has already been found. Sure, I'll appoint an attorney to represent you. He is entitled to bond, right, Ms. Fleming?
Yes, Judge.
Does the state wish to be heard on bond?
Your Honor, state would just ask that you stay the bonds that were currently set. They are both F3s. However, state's main concern is he does have at least 2 prior failures to appear, as he is also a multi-state offender. So state just asks that you stay the 2 bonds. I believe the age of the alleged victim was 12.
That's what she's saying.
Ms. George, do you have any argument about bond?
Your Honor, I would just ask that you consider the fact that he does not have any other crimes similar in nature. When setting the bond, also it appears he's been in the Orlando area for over a year, showing community ties. So I just ask that you consider that when setting the bond. His last conviction was in 2019, and that was for a no valid and another nonviolent offense of false ID.
All right, sir. I'll stay the bond at $50,000 on count 1, 35 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't have contact with any minor child under the age of 18. You can't be within 1,000 feet of the victim's residence or school. You can have no contact with any witness in the case. Are there any other conditions the state would request?
No, Your Honor.
Robert Harrison.
22 CF 13609. Mr. Harrison, you're here charged with trafficking and methamphetamines, possession of methamphetamine, possession of drug paraphernalia, possession of cannabis, less than 20 grams. At this time, I'll appoint an attorney to represent you. There is probable cause. Did you wish to be heard on bond, Ms. George?
Your Honor, I just would ask that you consider reducing count 1. He is a military veteran. He's retired, actually, military. I believe it was $50,000 was the bond that was set, Your Honor. And I would just ask that you consider reducing that given his circumstances financially. I don't see him being charged with any other trafficking on his record. I see some possessions, but no trafficking.
Mr. Harrison, you were in the Air Force for 20 years?
Yes.
Where were you stationed?
At Langley, Chinook, Shepherd Air Force Base, Lackland.
And are you a disabled combat veteran?
I'm disabled. Afterwards, I had, I'm like 80%.
So you have someone helping you get those benefits from the VA?
Yes, yes, ma'am.
My dad was a veteran,
Yes.
30 years in the Navy.
Yeah, I did Special Ops, Air Force.
Well, thank you for your service.
Thank you.
I'm sad that I'm seeing you this way, Mr. Harrison, however.
Yes, ma'am.
Sounds like you had a distinguished career serving your country, but some things may have changed. Ms. George, does your office have connections with the VA? Do you help them get more connected? Because I wonder if there's any other services he's not connected with.
Yes, Your Honor, we do. And I believe we have a drug court as well, Veterans Court. So we will be able, social services will go out and speak with him, and then we'll give him the services that are recommended.
All right. Well, Mr. Harrison, thank your attorney on your way out the door, because based on her argument and your service to your country, I will reduce this bond. I'm sorry, did the state want to give me a, I'm sorry. I'll reduce the bond to $20,000. On count 1, 150 on 2, 100 on 3 and 4. Sir, you can't have contact with any known drug dealers. You can't possess any controlled substance without a valid prescription. You understand?
Yes, ma'am.
All right, sir, good luck again. Thank you.
Thank you, sir.
Yeah, I'm ready.
Sierra Ornament.
And Your Honor, I don't have the case number because it's a city case. I don't know why I never get those.
I don't have it either. They don't come on the.
Okay. And in this case, Your Honor, I just ask that you stay the bond. She is in comp proceedings, or not comp proceedings, but she has been deemed incompetent in a prior case, and I do have concerns about her competency after speaking with her.
All right, I'll appoint your office, Ms. George. I'll stay the bond. There is probable cause here, Ms. Mack. I reviewed it before court. What I need you to do is stay in touch with your attorney. Do you understand? Good luck, Ms. Mack.
Your Honor, state would also ask for a no return.
I'll order no return.
Yep. Hold it right there.
Who's that from?
Hold it.
I'm sorry, tell me your name.
Hold it. Your last name? Waiter, R-I-T-H-E-R.
You're here in 22 CF 13611, charged with criminal mischief, damage greater than $1,000, and battery. There is probable cause. I'll appoint an attorney to represent you. Your bond will be $5,000 on count 1, $100 on count 2. With special conditions, you can have no contact with the victim. You can't return to the scene. You can't possess any weapons, firearm, or ammunition. You understand? 5,000. Good luck.
My name is Christopher Alexis Rodriguez.
22 CF 13600, you're here charged with grand theft of a motor vehicle. There's probable cause. I'll appoint an attorney to represent you. Your bond is $5,000. You can have no contact with the victim, any witness, or co-defendant in the case. Good luck, sir.
Thank you, ma'am.
William Kirk.
Where's Kirk? Oh, and, you want to accept, right? Okay. Yeah. Your Honor, in case number 2022 CT 994AA, Mr. Kirk is here for arraignment on a driving while license suspended or revoked. The offer from the state was an adjudication of guilt, credit, time served, as well as court costs. Mr. Kirk would like to accept the state's offer and enter a plea of no contest. I did go over the rights he would be giving up. He understands those rights and would like to accept the state's offer.
Raise your right hand, please.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am.
All right, Mr. Kirk, you heard what your attorney said. Is that what you wish to do here today?
Yes, ma'am.
You understand the rights you're giving up by entering a plea of guilty or no contest?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
Did you go over this form with your attorney?
Yes, ma'am.
Is that your signature?
Yes, ma'am.
All right, at this time, how do you wish to plead to the charge of driving while license canceled, suspended, or revoked? I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty. Order that you serve 29 days in custody, give you credit for the 29 days that you've served. I have to order that you pay court costs. Sir, do you have a job?
No, ma'am.
All right, I'll give you a year to pay those.
Can it be a year upon release, Your Honor, because he has trafficking cases?
Yes, a year upon your release.
So,
Good luck, sir.
state.
Paul Highslope.
And Mr. Highslope is here on arraignment in case number 2022 MM 714280. He's here for defraud of an innkeeper, and the offer from the state is an adjudication of guilt, credit, time served, no return to El Cilantrillo Restaurant located at the 1301 Florida Mall Avenue. There's also restitution in the amount of $38.34 to the restaurant, Your Honor, and court costs. And Mr. Highslope would like to accept the state's offer and enter a plea of no contest. We did go over the plea form. He understands all the rights he has to give up in order to accept the state's offer.
Sir, raise your right hand.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, you heard what your attorney said. Is that what you wish to do here today?
Yes, ma'am.
You understand the rights you're giving up by entering this plea?
Yes.
Do you have any questions for me about these rights?
No, ma'am.
All right, at this time, how do you wish to plead to the charge of defrauding an innkeeper?
No contest.
Sir, I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 34
34 days.
days that you've been in custody. I have to order that you not return to the El Cilantro restaurant at 1301 Florida Mall Avenue and pay restitution in the amount of $38.34 plus court costs. Sir, do you have a job?
Not at the present time.
All right, I'll give you a year to pay that.
Your Honor, may I approach with the restitution order?
Yes, please.
And it's 35 days, Your Honor. Enjoy your Thanksgiving.
I'm sorry?
35.
I'm sorry, he has 35 days.
Okay, 35.
Surely he won't object to that.
No.
Leon, Your Honor, refused.
I'll find his refusal a willing waiver of his appearance today. Oh, it's your client, Counselor.
Yes, Your Honor. Mr. Leon is here in case number 2022 MM701280. He's here for arraignment on a resisting an officer without violence. I will waive his appearance and enter a plea of not guilty, Your Honor.
Division 82, pretrial conference, February 16th at 8:30, courtroom 9B.
Aaron Devon Mack.
Mr. Mack is here in case number 2022 MM705080. He's here on arraignment on a petty theft. The offer from the state is a withhold of adjudication, credit, time served, no return to the 7-Eleven located at 480 North Orange Avenue. There's restitution in the amount of $10.86 to 7-Eleven. And Mr. Mack would like to accept the state's offer, enter a plea of no contest. We did go over all the rights he would be given up. He understands those rights and would like to accept the offer, Your Honor.
Raise your right hand, sir.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, sir, you heard what your attorney said. Is that what you wish to do here today?
Yes, ma'am.
You understand all the rights you're giving up by entering this plea?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
Did you sign this form?
Yes, ma'am.
You went over that with your attorney?
Yes, ma'am.
All right, sir, at this time, how do you wish to plead to the charge of petty theft?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 38 days he's been in custody. Sir, I have to order that you not return to 480 North Orange Avenue and pay restitution in the amount of $10.86 to 7-Eleven, as well as court costs. Sir, do you have a job?
No, ma'am. No, ma'am.
How old are you?
30.
You're 30?
He's been incarcerated, Your Honor, that's why.
Oh, does he have other charges?
He did, but he resolved them, so he'll be going home today. So.
All right, well, tell me how long you need to pay that.
How long they've accepted, are you on
A year.
When are you getting a job?
Year.
When are you getting a job?
As soon as I get out.
You don't need a year to pay this. You're 30, you look like you're in great health. When are you getting a job?
He said as soon as he gets out, he's gonna try. So could we do at least 6 months, Your Honor? Or he has to, his driver's license is gonna be suspended.
All right, I'll give him 6 months.
Thank you.
May I approach?
Good luck, sir. That was different than the other ones.
Yes.
When they're 65 and he's 30, he could have 2 jobs. Look at him. He's just fine.
I know he is.
Dylan Martinez.
22 MM 7884. You're here charged with battery. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500 with special conditions. You can have no contact with the victim, no return to the scene. You can't possess any weapons, a firearm, or any ammunition. Do you understand? All right, good luck.
Your Honor, based on the affidavit, it appears that the victim was moving out. Could we do a maintain separate residence and a one-time return with law enforcement? If she's not there, then she can stay, because I believe she lives there with her father.
All right, I'll do that. So it's maintain separate, one-time return. Thank you.
Your Honor, Velasquez bonded.
Thank you.
Terrence White.
And in this case, Your Honor, there is no offer to resolve.
White?
There is no offer.
What is it, white?
Oh, yes, Your Honor.
Okay, thank you, sorry. 22 MM 7886, you're here charged with petty theft. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with any victim, witness, or co-defendant and not return to the scene. Do you understand? Good luck.
Jeremiah Rojo.
22 MM 4301, you're here because a capias was issued for your arrest for failing to appear for court on a charge of assault. The bond authorized on that capias is $1,000. I'll appoint an attorney to represent you. Good luck, sir.
Alfonso Anderson.
Thank you.
And Madam Clerk, could you please state the case number, because it's a city case, I don't have it.
Wait, I don't either.
2022 MO 1289 AO.
1289 AO. Mr. Anderson has been given an offer from the state on his state misdemeanor, right here, case of a withhold of adjudication, credit time served, and no return to 511 Boston Avenue, as well as court costs. Mr. Anderson would like to accept the state's offer and enter a plea of no contest. And we did go over all the rights he would be given up. He understands those rights and would like to accept the offer, Your Honor.
Raise your right hand, please.
Mr. Anderson, you.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Talking to you.
All right, sir.
Yes.
You heard what your attorney said. Is that what you want to do here today?
Yes.
And you understand the rights you're giving up by entering this plea?
Yes.
Do you have any questions for me about these rights?
She's talking to you.
I have one question.
Yes, sir.
Officers took my phone.
Yeah, they give it to you.
When you get arrested, they take everything and they put it in your property?
No, they did not. They didn't put it in my property. They took my phone. It was on my. I had it in my possession, and I asked them about it, and they just laughed about it. So, and I know in this phone situation, there's some information on this phone, and they wanted to come get this phone. And the problem is, they had a snitch that was in the house.
Stop.
And I don't know, it's a problem.
Well, are you asking me about how to get your phone back?
Yes, that's all I want is my phone. I don't care about no information, I just want my phone.
So what you can do is, whatever agency arrested you, I don't know if it's the sheriff's office or Orlando Police Department, what you can do is you can go there and ask for your property back. Your attorney's office probably has some information about that. Ms. George, do you guys have information you can provide?
I can find out, Your Honor.
Okay.
They were saying, ma'am, they were saying that, you know, it's like they left it in the house. Usually when they take your property, they put it in your pocket or something. When they, you know, it was in my possession, it was in my hand. They took it out of my hands. So they should at least put it in my pockets or something.
Right, or they might have,
This
They
phone
might
is
have-
registered to me.
they might have taken it like for evidence or something, but you can get it back.
Evidence?
Right, that's what police officers do. They'll collect things and they put it in evidence, but you can get it back, especially once the case is over.
Where can I get my phone at?
Well, that's what I was just telling you. It depends on the agency.
It's Orange County. I mean, OPD.
Okay, so then the Orlando Police Department would have your phone.
Okay, thank you.
We'll see if Ms. George, if you can give him any information about that.
Yes, Your Honor.
All right, sir, do you have any questions for me about the rights you're giving up?
No, ma'am, I'm good.
All right. At this time, how do you wish to plead to the charge of violating state misdemeanors?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the
1 day.
1 day you've been in custody. Sir, you can't return to 511 Boston Avenue. You understand that?
Yes, ma'am.
All right. Good luck, sir. Oh, and court costs a year.
Right here, these are your papers. You gotta say your name, I'm sorry.
Jerry Belcher.
Did I get the pen? And Madam Clerk, it's a city case, I don't have. 1290AO. And Mr. Belcher is here on a state misdemeanor. Thank you. City ordinance violation case, Your Honor, and the offer from the state is an adjudication of guilt, credit time served, no return to 5265 South John Young Parkway, as well as court costs. And Mr. Belcher would like to accept the state's offer, enter a plea of no contest. We also went over all the rights he would be given up. He understands those rights.
Raise your right hand, sir.
Yes.
All right, sir, you heard what your attorney just said. Is that what you wish to do here today?
I'm sorry, ma'am.
Is that what you want to do here today? What your attorney just said?
Accept the offer, some of the offer.
Yes, ma'am.
All right, you understand the rights you're giving up by entering a plea today?
Yes.
Do you have any questions for me about the rights you're giving up?
No, ma'am.
All right, sir, at this time, how do you wish to plead to the charge of violating state misdemeanors? It's a trespass.
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the
2 days.
2 days you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay that, and that you not return to 5265 South John Young Parkway. You understand? All right, good luck, sir. You have 30 days to appeal in writing.
Your name, sir?
My name is Chad Diaz.
Matt,
We don't have a case number.
Mr. Diaz is here for an open container. The offer from the state is an adjudication of guilt, credit time served, and court costs. Mr. Diaz would like to accept the state's offer, enter a plea of no contest. We did go over all the rights he would be given up. He understands those rights, Your Honor.
Raise your right hand, please. Sorry. For the clerk to swear you.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, sir, you heard what your attorney just said. You can put your hand down. Is that what you want to do here today?
Yes.
You understand the rights you're giving up by entering a plea?
Yes.
Do you have any questions for me about these rights?
Just one question.
Go ahead.
Can Social Security the first time December 28th?
Wait, can you get closer to the microphone?
Wait a minute. Yes.
Oh, Your Honor, he's about to get Social Security disability, so he's asking if you will reduce the fees to a civil judgment.
All right, I'll do that. At this time, Mr. Diaz, how do you wish to plead to the charge of open container of an alcoholic beverage?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the
2 days.
2 days you've been in custody. I have to order that you pay court costs, and I'll reduce that to a civil judgment.
Thank you.
Good luck, sir. You have 30 days to appeal in writing.
Joe John is refusal, Your Honor.
Ms. George?
I will waive, Your Honor.
All right. I'll appoint your office. I'll state there's probable cause. I'll stay the bonds. That's it.
Yes, say your name.
Crystal Janae Hamilton.
Wait, who?
And Madam Clerk.
2022 MO 1293AO.
And Ms. Hamilton is also here on a city violation of a trespass, Your Honor. The offer from the state is an adjudication, credit time served, no return to 511 Boston Avenue, and court costs. Ms. Hamilton would like to accept the state's offer and enter a plea of no contest. We did go over all the rights she would be given up. She understands those rights. And in exchange for this plea, I would ask that you take no action on the out on bond, Your Honor.
Raise your right hand, please.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Your Honor, I missed the case number when we were signing, sorry. On the top, I didn't hear it.
1293.
Oh, no, I didn't.
Ms. Hamilton, you heard what your attorney just told me. Is that what you want to do here today?
Yes, ma'am.
You understand the rights you're giving up if you enter a plea?
Yes.
Do you have any questions for me about those rights?
No, ma'am.
At this time, how do you wish to plead to the charge of violating state misdemeanors?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the
1 day.
1 day you've been in custody, order that you pay court costs. I'll give you a year to pay those. You cannot return to 511 Boston Avenue.
Okay.
All right, ma'am, you have 30 days to appeal in writing, and I'll take no action on or out on bond cases.
So I go home?
Yes. Thank your attorney.
You're welcome.
Castellan York, it's a cash bond.
My name is Charles Moodlin.
22 CT 3466. You're here because a Capias was issued for your arrest for failing to appear for court. There's a $2,000 bond authorized on the Capias, and I'll appoint an attorney to represent you.
Yes, ma'am. Could I?
She's gonna ask the same thing. I already told her they're not gonna.
Could I? I'm sentenced in Hillsborough County to 364. Could I just stay here and do that time? Because I live here, and they have a hold on me, but I'm already sentenced by the judge. I've already seen them. My court case is over. But could I stay here because I live here, and it's more convenient for me because they're not gonna give me a bus ticket back home, and I'm still gonna have to come back to court here anyway.
I'm sorry.
Please.
She has a hold for Hillsborough, and she's trying not to be transported.
Because I just came from there, but I'm sentenced already. I don't have to go to court there no more.
So I can't tell them what to do with their holds. I don't have jurisdiction in Hillsborough County. I only have jurisdiction here. So if Hillsborough County is saying you have to come back, I can't stop that.
All right.
I'm sorry.
But could I ask them to be transferred here?
You can.
Okay, thank you.
Yes, ma'am. Good luck.
Did I miss Badur?
He was seen yesterday.
I'm sorry?
He was seen yesterday.
He's what?
He was seen yesterday in court. You addressed him yesterday.
Greg Paul responded.
Brian Garcia, Augusto.
22 CT 92, you're here for failing to appear on a charge of driving while license suspended. There's no bond authorized on that Capias, and I'll appoint an attorney to represent you.
Your Honor, state did convey an offer to Mr. Garcia of an adjudication of guilt, credit time served, and cost of investigation of $148.89 to Maitland Police Department.
How long has he been in custody?
Today, 1 day so far.
He's got out-of-county warrants for Dwillis's, prior convictions for them.
So decide what you want to do. Yes or no?
I was gonna say I won't accept that, but if he wants to do it, I'll accept it.
Dwillis arrest, but I only see one prior Dwillis conviction. So this will be his second, so he'd be on the road to be HTO.
Okay, so then I will accept it if he wants to do it.
Sorry.
You said that 148.89 to, where is it going to?
Maitland.
Oh, Maitland, okay. I just never seen the MAPD. That's what I was like, I don't know.
But, Ms. George, did you explain to him about HTO? Because it says he's got 3 out-of-county warrants, prior Dwillis's. If this is his second and he pleads to it today, and it counts toward that, his next one is. Could be. I'm not saying it is.
So he also has a current open orange, or no, current open Seminole.
Matt,
Willis.
Pretrial,
Yeah.
does he have a bond on that warrant? He is under the impression he has a bond, and I keep explaining.
This FTA? No.
I wrote a letter to the judge.
Go ahead.
Hold on, before you say anything, raise your right hand.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
All right, I need to make sure you understand that everything you say is on the record and can be used against you later. You understand that? Okay. If you still want to talk to me, you can.
Yes, absolutely, thank you. Your Honor, I wrote a letter to the Judge Evelyn Jewett on the case about a week ago, requesting that a bond be set on the warrant, and I would turn myself in. And I got an email back with that request being granted, and it's on the docket.
It is actually,
online.
he's right.
Hold on, I see it in the court file.
Yes, he is right. They granted the $1,000 bond, and she set him for a status hearing on December 16th.
I do, I see that order.
Yes.
That's correct.
Your Honor, I'd recommend that he does not plea, because he currently has an open Seminole Dwellis, another Volusia Dwellis, open Volusia Dwellis. There's at least like 5 or 6 open that I see in 2022.
Yeah, see, that's what worries me.
Yes. So based on that, Your Honor, and we could see it here, because he didn't have an attorney, I would ask that you appoint us so we can help him get his driver's license, since we have a program, and set the bond at $1,000, as the judge did sign off on that.
I will. She set the bond at $1,000, so that is your bond. I will appoint the public defender's office. And sir, you definitely want to call your attorneys right away, because you have a lot of these out, and what's going to happen is it's going to be a felony. So instead of 60 days in jail, the maximum penalty is 5 years in prison. That's a lot for a driving charge, but you have a lot of them. So talk to your attorney.
Thank you, Your Honor.
Yes, sir.
Lozano, Oregon is bonded, Your Honor.
Junior Ramos?
Wait, so Raul bonded, right? Okay. Yeah. In Mr. Ramos' case, Your Honor, there was an offer, however, he's currently trying to get his driver's license. He doesn't want it to H2O him. He is employed full-time and school. So I would just ask that you set a bond on the new law violation. Set a higher bond on the new law violation and take no action on the out on bond. I believe they set it at 500, but I would just ask for a higher bond on the new law, take no action on the Osceola case, and let us help him get his driver's license. He is in the process of working off the fees that he owes. Not about the facts. Oh, go ahead, yeah.
Literally, I know it's not an excuse. I'm not trying to make any excuse.
Before you say anything, everything you say is on the record and can be used against you later. You understand that? The only thing we're here today for is probable cause and bond.
I just want a bond.
Okay. That's very wise. I mean, you can say anything you want, but you don't have to.
I want a bond.
How about I give you a bond?
Thank you.
Your bond is $500. Based on your attorney's argument, I'll take no action on your out on bond case. Thank her.
Thank you, ma'am.
Sir, don't drive without a valid Florida license.
Thank you, ma'am.
And there is probable cause.
Ma'am, I didn't hear what you said at the
Oh,
end.
don't drive without a valid license.
So just don't drive without a valid license. You'll be right back here.
Thank you, ma'am.
Good luck.
Your Honor, Roe Evans bonded.
Luis Gabriel Vasquez Alicia.
Taylor, I missed this. Did you give an offer on that?
Vasquez? It's a DUI. Do you want one?
No. I don't remember seeing one. That's why I asked. Okay.
I
just wanna
didn't
make sure.
convey one, but
Okay.
do you
It's
want?
a
Nope.
2019 CT 814. Hold on a second. You're here because a Capias was issued for your arrest for failing to appear for court on a DUI. The bond authorizes $1,000. Sir, I see that you have an attorney, so I'm not going to appoint an attorney. But if you are unable to if your attorney doesn't want to represent you anymore or something like that, you can always ask for a PD.
Yes, you do. Allie Kendall.
He doesn't represent me.
I can't hear you.
You withdrew a while ago. He doesn't represent me anymore.
I don't see a withdrawal.
According to the clerk file, the court file, he does.
Yeah, he hasn't withdrawn.
He has not withdrawn. So you'll want to call him right away.
Hold on.
I see
He
him-
actually filed one.
I see an order to withdraw.
Did they grant?
Wait, where?
It was 11/19.
I see
21.
one,
And
4/18 of 22. Hold on. I don't know if it's, which attorney it is, 1 second.
I see it, but I don't know if it was granted. You see it was granted?
I see it granted, but I don't know if it was a prior PD's withdrawal.
Hold on.
It just took a while, hold on.
Motion to withdraw January 15th.
Oh, he did withdraw.
Order regarding, yeah, withdrawal on 4/18/22.
The court file still shows him as attorney of record, but he did withdraw.
I did see that.
All right, does he qualify? Yes. All right, I'll appoint the PD. Good luck, sir.
How you doing today?
Good.
Anthony Bryant.
20 CF 3892, a warrant was issued for your arrest, and then you were subsequently charged by information with grand theft of a motor vehicle.
You're,
I'll appoint your office.
he does qualify for pretrial release. I don't see any failures. Oh, I do see two. Is that two? Yeah, I do see two. He does qualify for pretrial release. I would ask for pretrial release, Your Honor.
State.
He did also serve, he's a military veteran as well, Your Honor.
What branch of the armed services? Where were you stationed?
I was facing in Fort Worth, Georgia, Augusta, Georgia.
Thank you for your service. I'll place you on pretrial release. With special conditions, you can have no contact with any victim or witness in the case. Good luck, sir.
And Your Honor, it's showing that he resides in South Carolina.
As long as he maintains contact with his attorney and appear for all court appearances, I would just ask that you allow him to return. You still reside in Georgia?
I'm fine with that.
Yeah. Okay.
It just means you still have to come to court in Florida. You as well. Ms. George, I'll appoint your office.
We'll waive the appearance.
All right, there is probable cause. I'll stay the bond, 50,000 on count 1, 150 on 2, and 100 on 3 and 4. No contact with any known drug dealers. Is this a co-defendant case? I thought so.
This is the co-defendant of the veteran earlier.
Right. No contact with the co-defendant. $150.
You gotta say your name.
Ronnie Francois.
22 CF 13620. You're here charged with possession of methamphetamine. There is probable cause. I'll appoint an attorney to represent you. Counsel, he's out on bond.
Yes, Your Honor. I would ask that you take no action in case number 2022 CF 12615AO. It occurred October 15th. It's non-related, Your Honor. So I just ask that you consider that. I don't believe the state has filed yet, but I would just ask that you consider that and not take any action on the out on bond.
He was arrested 10/30, so it hasn't been 30 days yet.
Oh, it's a warrant.
Yeah. I'll take no action. Did I already do bond on this?
No.
Your bond is $1,000. You can't have contact with any known drug dealers or possess any controlled substance without a valid prescription. Good luck, sir. Ms. George, you're on fire today.
Trying to go eat some turkey.
I'm just saying, I'm like giving you everything you asked for.
Oh, say your name.
Edwin Gonzalez.
20 CF 7686. A warrant was issued for your arrest, charging you with criminal mischief. Another judge has already found probable cause. I'll appoint an attorney to represent you. What's the bond in the warrant? Thank you. It has no bond?
Oh,
Why would it be a no bond on criminal mischief subsequent offender?
I have no idea, Your Honor.
We have since filed. We filed the F3
Oh, it's a
subsequent-
capias. It's a probable cause capias.
Yeah.
What's the reason for the no bond, though?
I have no idea, Your Honor. He's fully employed, lived here for over a year, so I'd ask for a reasonable bond in this case, Your Honor.
Ms. Fleming, any objection from the state to a reasonable bond?
No, Judge.
I can't figure out why it would have said none.
I'm looking at what was allegedly damaged.
What was it?
Slammed the back door, breaking the bolt lock. I believe there was, it started at Victoria's Secret, allegedly took someone's phone. They went back to the house, continually arguing. He punched the passenger windshield. Then asked him for my car key. He threw it at me, slammed the back door, breaking the bolt lock, damaged the windshield and the back lock on the back door of my house. It was allegedly a door and a windshield.
All right, your bond is $5,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means? Do you live there?
No, ma'am.
All right, you can't return to the scene for any reason.
I don't even know who it is. I don't.
All right, what's the address, Ms. Fleming? Oh my gosh, I want to say May.
The victim is Jeanette Rojas. Location was 8401 Arrowhead Circle.
You can't go back there, sir.
Yes, ma'am.
All right, good luck.
Thank you so much.
Good morning.
Amy Renee Guillory.
I don't have a case number. Ma'am, probable cause Capias was issued for your arrest, charging you with burglary of a conveyance with assault or battery. I'll appoint an attorney to represent you.
We have also filed.
You filed the information charging the PBL?
Yes.
All right, at this time, ma'am, you don't have bond, but even while in custody, you can have no contact with the victim or any witness or co-defendant. Do you understand that?
I don't understand the no bond part.
So like,
Because this is a first-degree felony punishable by life in prison, you're not entitled to bond. So I've appointed an attorney to represent you. They're going to have to file a bond motion and schedule a hearing in front of your trial judge.
And do you know how long that could take?
No. But that's the information to call your attorney. Good luck, ma'am.
Hello, my name is Jared Kennedy.
22 CF 13367. You're here because a warrant was issued for your arrest for violating your sex offender probation. Sorry, sex offender reporting requirements. At this time, your bond is $15,000. I'll appoint an attorney to represent you. What's he out on bond for?
she's not asking you.
Violation of pawnbroker's action. And
Wait, what?
Petty theft, 2 prior convictions, a violation of pawnbrokers act.
Yeah. Dealing in stolen property, receiving money from pawnbroker, petty theft, 2 prior.
Mr. George, I'm inclined to revoke his bond.
Oh, this is him. I was confused. I was looking at the wrong person.
Let me check dates.
It doesn't matter if it's 2 days later. Your Honor, given that they're unrelated charges, the requirements, as we know in Florida, are very hard to keep up with. He did report 2 days later, although he still violated his reporting requirements. He is currently trying to maintain them, and he is transient, which is why. So I just ask that you consider that. Take no action on the out on bond as they're unrelated, and make it a requirement that he report within 24 hours of being released, and maintain all other reporting requirements. But this case was from 2020. He hasn't picked up any new petty thefts or dealing in stolen property or anything to that effect.
What says the state?
Your Honor, state will leave it within your discretion. It appears the failing to register was multiple different things. However, being overdue with a 30-day transient check-in was the main one. So state will leave it within your discretion, Your Honor.
I read the affidavit. I signed the warrant.
But you still have to.
All right. Based on your attorney's arguments, I'll take no action on the out on bond case, but I'm staying your bond at $15,000. On the failing to report, Mr. Kennedy, once you're released, you have 24 hours to report. You understand that? And you must maintain all of your reporting requirements.
Thank you so much.
Good luck, sir. Thank your attorney.
Matthew William.
You have two cases, 22 MM 5663. You're here charged with violation of conditional release. There's a $2,000 bond authorized, and I'll appoint an attorney to represent you. In 22 CF 12319, a probable cause Capias was issued for your arrest, charging you with aggravated stalking after a court order.
And we have
Ms. Fleming,
we filed on that 2 charges, the aggravated stalking after court prohibition, 2 F3s. And I believe it is the same victim as the violation of the conditional release on that previous BAT DV case.
All right, I'm appointing attorneys in both cases. Yes. Oh, he has an attorney, Ms. George.
Is that
Yes.
private?
He couldn't appear today. He said he was, had to be away. He said
Okay.
he left a voicemail, for your office. That's what he told me.
He may have, but I'm not at my office, I'm at the jail, so
Of course, yeah.
I wouldn't be able to,
Yes, ma'am.
hold on a minute.
And yes, the victim is the same within the both cases. Ms. Weaver?
Okay, well, what says the state on bond?
Your Honor, given that they are both F3s, he is entitled to a bond. State's concerned because his history seems all BAT DV related history with, I believe, with the same victim.
Same victim, it is, that I have access to.
And I do believe there is a temporary protection order that's going to be served shortly, also with this same victim. So state would just ask that you take that into account when setting his bond. State's just concerned because he's not complying with court orders.
And my only argument, Your Honor, is that although he has the arrest, he has no convictions for domestic violence. So it appears the victim has not moved forward on those charges that I could see. So I just ask that you also consider that. I don't see any convictions on his record for battery or any other violent history.
All right, Mr. Lamb, I want to make sure that you hear me very carefully.
Yes, ma'am.
You are entitled to bond. I have to give you a bond.
Yes, ma'am.
But it is very clear to this court that you are either unwilling or unable to comply with court orders. That's not going to happen with my court order today. Do you understand?
Yes, ma'am. Absolutely.
I'm going to tell you what you're not allowed to do, and you're not going to violate that.
Absolutely.
You cannot have any contact with this victim. Do you understand what no contact means?
I do, yes, ma'am.
What does it mean?
It means they don't exist to me.
Right, you cannot speak to her, send a text message, a call, message through family or friends, Snapchat, Instagram. What do the kids use now?
TikTok.
TikTok, no social media.
Yes, ma'am.
You can have no contact with this person. Is that clear?
As far as I'm concerned, ma'am, she does not exist to me. Swear.
All right, you can't possess any weapons. You can't be within 1,000 feet of her residence or place of employment. Any other conditions the state would request?
No, Your Honor.
All right, so on each of the aggravated stalking counts, your bond is $25,000. On the violation of conditional release, it's $5,000. Good luck, sir.
25,000 for each charge?
Yes.
Okay.
Yes.
Name, hi, how you doing? My name is, but I'm sorry, I kind of started a little bit, but,
I'm sorry, I can't hear you, sir. What's his name?
Macon Michael, Your Honor, he has a speech condition.
Oh, okay. But that's your name, Macon?
yes,
Your last name is Macon?
yes, but make sure you add the junior though, because I think it's something where my dad, and it's like, where like, something, like some charges with my dad, I think it's on,
Oh, it looks like you, but it's not.
yeah.
All right, so I have Michael Leonard Macon Jr. Oh my gosh.
That's a tongue twister.
All right, Ms. George, your office is already appointed in this case.
Yes, Your Honor.
Sir, you're here because you failed to appear for court
Yes, ma'am.
on a carrying a concealed firearm charge. The judge didn't authorize any bond on the Capias, so I can't give you a bond. So you're gonna wanna stay in touch with your attorney, you understand? Good luck, sir.
James Richard.
22 CF 13617, you're here charged with aggravated assault with a firearm. There's probable cause. I'll appoint an attorney to represent you. Do you wish to be heard on bond, counselor?
Your Honor, state we just asked for a reasonable bond. Mr. Richards doesn't seem to have too much criminal history. And it looks like his last failure to appear was 2011. So they would just ask that you take that into account. I believe it is alleged that he pointed the firearm towards the victim and made certain threats. So they would just ask that you take that into account when setting his bond, as he is otherwise entitled to it.
I would ask for a reasonable bond as well, Your Honor. He has community ties, not much of a criminal history. Last conviction was in 2014, so I just ask that you consider that when setting the bond in this case.
All right, Mr. Richards, your bond is $5,000. You can have no contact with the victim or any witness in this case. Do you understand?
Yes, ma'am.
You can't possess a weapon of any kind, which includes firearms or ammunition.
Yes.
Any other conditions the state would request?
State, I believe he potentially lives there. The state's only concern is the witnesses stated that he made threats that he would basically shoot up the buildings where they lived.
But it's where he lives.
It is, Your Honor. So,
Your Honor, that's where he resides. He's disputing the allegations that are stated. They live, I believe the victim and him do reside at the same apartment complex. However, they don't live on the same floor, so I just ask that you allow him to return home, but he has to understand that he cannot have contact with the victim, and if he sees the victim, he has to go in a different direction. He doesn't have anywhere else to live.
All right, I'm not going to order that you can't return there, but you heard what your attorney just said. That is very wise advice, because here's what's going to happen. If you and the victim are coming towards each other and the victim calls the police and says you're having contact with him, you're the person that can get arrested. You understand that?
Yes, ma'am.
Not him, because I've ordered you not to have any contact with the victim.
Yes, ma'am.
So,
and Your Honor, just for the record, it's a woman.
I'm sorry, her. So you understand that you're the one who has everything to lose if you're not careful.
Yes, I already know. I'm here now.
Right. All right, good luck. Thank you. I read so many of them that the facts all run together.
Understood. I just wanted to make sure he was clear.
Yeah, thank you for doing that.
No, it's a felony. They don't plead those here.
Kyle Antonio Rodriguez.
22 CF 13596. You're here charged with burglary of a dwelling, possession of methamphetamine with a weapon, possession of drug paraphernalia, and petty theft.
Your Honor, this is Rodriguez, J-L, J-A-E-L.
I'm so sorry. I have the wrong Rodriguez.
Yes.
Hold on. Thank you. Oh, here. Well, it was in the, I'm sorry. This is 21 CF 9766. You're here because a Capias was issued for your arrest for failing to appear for a trial management conference on charges of fleeing or attempting to elude law enforcement, possession of cocaine, possession of drug paraphernalia, and driving while license suspended. There's no bond authorized on the Capias, and I'll appoint an attorney to represent you. Good luck. No, this is this one.
Manuel Rodriguez.
22 CF 13596. You're here charged with burglary of a dwelling, possession of methamphetamine with a weapon, possession of drug paraphernalia, and petty theft. There is probable cause. I'll appoint an attorney to represent you. All right, I'll stay the bond at 5,000 on count 1, but it's 1,000 on count 2, 100 on 3 and 4. With special conditions, you can have no contact with the victim or any witness in this case. You cannot return to the scene. You cannot possess any weapons or any controlled substances without a valid prescription, and you can't have contact with any known drug dealers. Good luck, sir.
Wanza Thomas.
22 CF 13621. You're here charged with possession of cocaine. There is probable cause. I'll appoint an attorney to represent you. Did you want to be heard on bond, Ms. George? He's not interested in pretrial release.
Is he? Is that what it said? I don't see that he
I
qualifies.
don't have that he qualifies.
It says on the back, when he was interviewed, that he said even if the judge orders it, he's not interested.
Oh.
Well,
I respect that.
I want to try to get my weight, my health back. And, this is the only place I can do it, but if I can get out, you know,
Wait, you do want to get out or you don't want to get out?
I do. I do.
You want to be released on bond today?
Yes, ma'am.
Okay.
I can't afford it.
Okay, just give me a second. May we approach on this case, Your Honor?
Yes. Mr. Thomas, here's what we're gonna do. Today on this charge, I'm gonna release you on your own recognizance. Your attorney is gonna give you some information and try to get you some resources, but I need you to stay in touch with your attorney and I need you to do what your attorney's office says. You understand? Because she's trying really hard to get you some help. You should thank her. She's working really hard for you. But she can't help if you don't do what they tell you to do. Okay?
I just got released from mental health, you know, they were supposed to help me, but yesterday, but this happened, you know.
Okay, well, they're gonna try to get you some help. So stay in touch, okay? Good luck, sir. And as a condition, he can't do any illegal drugs.
Yes, ma'am.
Thank you, good luck, sir.
Eyes Vance.
You're here in 22 CF 13619, charged with possession of a firearm by a convicted delinquent and carrying a concealed firearm because you're 19. All right, I'm going to appoint the public defender's office to represent you.
Your Honor, he's unemployed, he does qualify for pretrial release. One thing I'd ask that you consider is the fact that when he did speak with the police, he was cooperative. He did take responsibility based on what I am reading in the affidavit. So I just ask that you allow him to be on pretrial release. I believe it's towards the last, he stated that he's claiming whatever illegal substances were in the back seat, and also that he advised them ahead of time. So I just ask that you consider that. I don't see any other charge on his record in reference to a weapon or firearm, so I just ask that you consider that and allow him to be on pretrial release.
What says the state?
Your Honor, state has no objection to PTR due to the charge that made him a convicted delinquent being a grand theft. It wasn't another violent offense. So state has no objection to PTR at this time with the condition of no weapons.
All right, Mr. Vance, I'm going to place you on pretrial release, but I want you to listen to me carefully.
Yes, ma'am.
You're not a juvenile anymore. Now, every time you get arrested and charged with an offense, you're an adult.
Yes, ma'am.
You have the opportunity to have a very different life.
Yes,
You should take it. You're 19. You could have 70 years of not being in jail. Don't come back.
All right.
I'm placing you on pretrial release so you don't have to post a monetary bond, but you can't possess a weapon, a firearm, or any ammunition. Do you understand that?
Yes, ma'am.
Don't be in the car with people doing drugs. That's gonna get you arrested again. You understand?
Yes, ma'am.
Your Honor, state would also ask for no contact with the co-defendant, Mr. Walker.
I will order that you can have no contact with the co-defendants or any known drug dealers.
Yes, ma'am.
Good luck, sir.
Okay, thank you.
Yes, sir. It's 19. Poke my eye out.
Sandra Walker.
.22 CF 13618, you're here charged with possession of cocaine. 21 MM 7672, a Capias was issued for your arrest for failing to appear for court. There's probable cause for the cocaine. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. And I see that you want to say something. Before you say anything, let me make sure you understand that everything you say is being recorded and can be used against you later. I'm also appointing an attorney to represent you. Maybe say it to Ms. George before you say it to me.
Oh, stop. Thank you, Your Honor.
All right, and on the Capias, the bond authorized is $2,000. You need to stay in touch with your attorney, ma'am.
What was the possession of cocaine bond amount, Your Honor?
$1,000.
Andre West.
22 CF 13622, you're here charged with tampering with evidence, petty theft, and resisting an officer without violence. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $5,000 on count 1, 150 on counts, I'm sorry, 100 on 2 and 3 each. You can have no contact with any victim or witness, not return to the scene. You can't possess or consume alcoholic beverages. Any other conditions the state would request?
No, Judge.
Good luck, sir. Stay in touch with your attorney. All right, anything else before court is adjourned?
Nothing from the state.
Nothing from defense, Your Honor.
Madam Clerk? Court is adjourned.